Welcome everybody to this event this evening at UCL Laws. Welcome to those in the room and to those online. We have a wonderful event tonight which we've called Insights into Environmental Judging. And we have some wonderful speakers who are going to offer their insights. Before we get into the speakers and what they will cover, I will explain a little bit how this is going to run. I'm Eloise Scottford. I'm a Professor of Environmental Law and Dean of the Faculty at UCL. I'm going to introduce everybody, and then there will be a conversation facilitated by Professor Liz Fisher, who I will introduce properly in a moment, between our two eminent judges on our panel, Justice Pain and Lord Carnwath. After the discussion, there will be a bit of reflection by Professor Fisher, and then time for questions. So those of you online, do put your questions on the online question function, which I can see in front of me, and those in the audience will have a chance to ask questions as well, and I will be as fair as I can in taking questions at that point. But we should have about half an hour for questions at the end. So we are really, really lucky to have three wonderful speakers this evening who are all in the same country at the same time, which is why we've taken advantage of that physical presence to make this event happen. First is Justice Pain, who is a visiting professor with us at the Faculty of Laws. In her day job, she's a judge of the Land and Environment Court in New South Wales in Australia, where she has held that role since 2002. Prior, so that I think the longest serving judge on that court, which is a very...
great.
Yeah, very significant achievement. And I'm going to set out when you're chairing these things, it is customary to rattle out CVs of distinguished guests, but I'm going to really go through them because I think it matters to understand the perspectives of our judges this evening, kind of the backstory of their careers. So prior to being a judge in 2000, when that started in 2002, Justice Pain was Director of the Environmental Defender's Office in New South Wales. She had environmental law and policy positions in New South Wales and Australian government. And so that's kind of that backstory led to the judicial office that she holds today. In addition, you are an adjunct professor and chair of the Australian Centre for Climate Law and Environmental Advisory Board at the University of Sydney. Now, competitor institution, friendly competitor institution on the other side of the world. And I've brought along a book that I wrote today because how I got to know Justice Pain was as a PhD student reading Gray and Minister for Planning, an amazing decision. And I wondered then, who was this interesting, wonderful person writing this fabulous judgment, and how lovely that you're here this evening. Lord Carnwath, Honorary Professor in our faculty, and Lord Carnwath has a different kind of career path leading up to holding his judicial office. He was called to the bar in 1968 in England, and he practiced planning, local government law, administrative law. In 1980, was appointed junior counsel for the Inland Revenue, took silk in 1985, did some major work on the enforcement of planning control for the UK government at that time, leading to law reform and a new piece of legislation. In 1988, was appointed Attorney General for the Prince of Wales, now King Charles III. In 1994, appointed a High Court judge. 1999, Chairman of the Law Commission. 2002, appointed to the Court of Appeal. 2007, the first Senior President of Tribunals. And in 2011, appointed to the Supreme Court of the United Kingdom. So that's the trajectory and CV and background of our two judges who will be giving us their insights into environmental law judging. Last but not least, Professor Liz Fisher, who we're also incredibly lucky to have with us this evening, Professor of Environmental Law at Corpus Christi College and in the Faculty of Law at the University of Oxford. Professor Fisher researches and is an expert in many areas of law, which I think is a bit of an occupational hazard of being an environmental lawyer. But at the moment, I think the way you would describe your fields of endeavour, administrative law, law generally, regulatory problems and practices in different legal cultures with a focus on environmental problems. I mean, you are an environmental lawyer, but yes, and all of that. Professor Fisher has multiple prize-winning books on administrative law, many books on environmental law, many articles. Is currently the General Editor of the Oxford Journal of Legal Studies, former General Editor of the Journal of Environmental Law, so a very important person in excellent scholarship being published and curated and encouraged in legal academia generally. He's currently the holder of a Leverhulme Major Research Fellowship looking at legal imagination and environmental law, which may come through in some of the questions this evening. And a particular reason, and I've brought another book along, which is a book that Professor Fisher has, and Brian Preston, who's your Chief Judge in the Land and Environment Court, has edited this book on an environmental court in action, Function, Doctrine and Process, which I know at least one of our audience members has been reading, because I gave her another copy to have a look at, which is unusual in being a book about a court, an environmental court. But that gives you special rights and I think expertise to be the questioner this evening of this panel. And with that lengthy introduction, I'm going to hand over to Professor Fisher to start the conversation going.
Thank you very much. I think as all that makes clear, I am a nerd, and I am an environmental law nerd. And coming back to this book, one of the reasons we wanted to do this was that a lot of people know about the New South Wales Land and Environment Court, and they think it's exciting, except they don't actually know what it does. And I think it's probably fair to say the same thing about environmental judging. It sounds really exciting.
Have a look at that. I think I haven't got my copy of it.
I'm not sure. It's hot off the press.
It's very good.
Didn't I write a preface?
You did.
Yeah, I got it. I'm still waiting for my copy, actually.
We can sort that out afterwards. But environmental judging is one of those things that people say, oh, that's really exciting. But what we really want to think about tonight is, well, what does it mean? What does it involve? And the first question I have, and Eloise eloquently described your careers, and both of you have long track records in the process of judging and adjudication. So my first question is really asking, what does that involve? And what does it involve in each of your courts? And what are the everyday aspects of it? So, Justice Pain, do you want to start?
Are you happy if I start, Robert?
Very, very happy.
You've got more courts to cover. So I suppose a bit of background about the court, because obviously that informs somebody who's been on it for 20 years, which frankly I can't believe the time has passed so quickly. So the court actually turns 42 this year. This book was supposed to come out on the 20th anniversary, but because of COVID, as with everything in our lives, everything happened 2 years later. So the book is very hot off the press, and I was fortunate to meet Liz Fisher earlier this year when she came to Sydney for the launch of it. So it's certainly a very timely publication, I would say, given how long the court's been in operation, and I guess for the reasons Liz has mentioned about really what does it do. So it does actually have quite a varied jurisdiction for a specialist court, and not every one of the cases I will be dealing with on a daily basis might deal with the environment per se. So perhaps if I talk briefly about the kinds of matters the court deals with, and then a bit about what the judges might do. So lawyers talk about merits review cases. Those are those development planning appeal types of cases. There are two classes of those in the Land Environment Court. The court's unusual in that it is a Supreme Court level court. We call it a Superior Court of Record, so it's a Supreme Court level court in New South Wales. But it does have commissioners, who many of whom are non-lawyers, as members of the court, and that is one of the big differences for this court. It probably would be viewed as combining court and tribunal functions in a Superior Court of Record, and as far as I know, that's very unusual around the world, probably only matched to some degree by something like the National Green Tribunal in India perhaps, and the Swedish Court of the Environment. So a lot of those merit review matters are on a whole range of developments, housing, should you have a garage, up to quarries, large quarries, sometimes large expressways, sometimes very controversially coal mines, although not very often. So a whole range of issues will be considered in a merits review context, and I think we're going to be asked a bit more about what's involved in that, so I won't spend more on that right now. We also do land valuation. When you compulsorily acquire land, that is when the government compulsorily acquires land in New South Wales and you don't like the amount you're offered, you can appeal to the Land Environment Court. So I have also become a judicial valuer of land, not something I was anticipating in my career, but those cases are often very long and extremely complicated, and they do take up quite an amount of judicial time. But judges probably also spend a lot of time, most time in judicial review and civil enforcement. And one of the hallmarks, and probably one of the reasons why the court has been able to develop the jurisprudence that it has, which is well documented in this book, over its history, is that we have open standing. Any person can take action to civilly enforce the major legislation in New South Wales. So that's led to some very interesting public interest litigation over time, and that's probably enabled some of the jurisprudence of the court to develop. Judicial review obviously is reviewing decisions of government bodies. It's bread and butter administrative law application, but in an environmental statutory context. So all of our jurisdiction is statute-based, but that doesn't make it simple at all. Statutory interpretation is part and parcel what some of the functions of the judges spend a lot of time on. The other thing that makes us unusual is we also have a criminal jurisdiction, so all major environmental crime must be brought before the Land and Environment Court. So that has meant over time some pretty extensive development of jurisprudence around environmental sentencing, and that's obviously something that judges do. We also have an appeal function from magistrates. Magistrates hear more minor environmental criminal matters, and if a prosecutor or a defendant doesn't like the result in the local court, they can appeal to the Land and Environment Court to a single judge, and we would hear that appeal function. And last but not least, we actually have a mining jurisdiction, but we don't seem to have a huge amount of matters in that, so I won't spend much time on that. But if I could just talk a bit more about judges versus commissioners, so to speak. So judges, as in most common law jurisdictions, are appointed for a fixed term, but it's a very long one. We're very hard to get rid of. Commissioners are appointed for a 7-year term, and that can be renewed. So they don't have exactly the same function as judges, and their duties are different to judges, but they are members of a Superior Court of Record in New South Wales, and that is an important distinction. And I suppose one of the reasons I'm not at all bored after 20 years on a judge is that I can sit in all of those classes of cases. That means as a judge I'm sitting in civil and criminal matters, and they're worlds apart, I find, in terms of the approach that is required in court and the sort of jurisprudence that develops. But also as a judge, I can sit, and judges do, in more complicated merit review matters. And one of the advantages of our system is that on a particularly complicated matter, the Chief Judge, who's Brian Preston, as you've heard, can allocate a commissioner, and sometimes two, although not very often, to assist a judge in a merits review matter. And so I suppose that's one of the arguments in favour of specialist environmental courts, is that mixing and matching, hopefully, of skills and qualifications to match what's before the court. So the commissioners have a variety of skills and knowledge and qualifications. Many are planners, architects, we have ecologists, an engineer, arborists, and there are 10 full-time, and I think there are currently 15 part-time commissioners who can be called on, and that means that their expertise can be, once again, hopefully brought to bear on a particular topic. And so that's certainly, I think, one of the strengths of the court, in addition to being able over time to have legislation which does have some pretty important principles in it. Ecologically sustainable development is a fundamental part of much of the objects of the legislation we look at. That requires us to look at things like the precautionary principle, intergenerational equity, etc. And so a lot of that jurisprudence over many cases over time has resulted in the court saying, I think, some useful things in that area. So those are some of the, I guess, more unusual features of the court, which over the long now lengthy history mean that it does have something of a reputation internationally, because it is not a model that's seen very often or at all anywhere else.
Fantastic. Robert?
Well, I can't match that.
Oh, go on.
Well, we don't have anything like that here, as you probably know. I mean, although I've always been, I'm here to talk about environmental judges. I'm not really an environmental judge at all. I've done a bit of everything, as judges have to do here. And of course, our system, I mean, I visited your court on 2 or 3 occasions. I mean, very fascinated by what it does. I'm longing to see this book. But, I mean, here, of course, the sort of functions you have are sort of scattered around to a large extent. I mean, a lot of the sort of your what we would call planning jurisdiction, merits review of planning decisions, is done here by planning inspectors who are normally acting as agents of the Secretary of State for the Environment. And so they only come to court on a sort of judicial review of the planning decisions. The valuation function which you have, here is done by tribunal, the upper tribunal of the lands group of that, so that's rather closer to your thing, that has non-lawyers sitting in it. And the criminal work is done here by the sort of criminal courts. We don't have any sort of the overlap between the civil and the criminal we have, except actually, interesting enough, in statutory nuisance. I mean, I was involved recently in a case about pollution from a landfill waste tip, where the local authority were bringing what are called statutory nuisance proceedings in the local magistrates' court. And now that's a sort of procedure which goes way back to the Public Health Act of 1875, I think it's a sort of, and somehow it survived as a slightly anomalous, because I mean, what happened in this case was they decided that rather than face a month in front of the local magistrates' courts with a lot of technical evidence, which might have been a bit difficult, they should try and go for mediation. And I was brought in as a mediator, and happily we got an agreement. So it's a very different sort of world. As a judge, I mean, I was a judge of the Chancery Division. We did get 1 or 2 interesting cases. I remember there's one particular case, which was one of the most interesting cases I had, about the radioactive matter escaping from the Aldermaston site during a flood and affecting a neighbouring conference facility. And there was an extraordinary issue, really a sort of nuisance, but also under a specific thing called the Nuclear Installations Act, which has a quite strict nuisance regime. But it raised all sorts of questions about the technical side of things, what had actually happened, and then to what extent had that caused damage, and then questions about valuation. And it so happened that it was during a sort of recession in the property industry, and they've been trying to sell it, so there's a whole issue about how you calculated damages. Worth looking up. It went to the Court of Appeal. It's a case called Blue Circle against the Ministry of Defence, and it's reported in the... my judgment wasn't reported, and that was before Bailey. But it's a good... The Court of Appeal were nice about my judgment, and so it's worth reading. But when I was in the High Court, I suppose my main sort of sphere of environmental work would have been reviewing a judicial review of decisions of planning inspectors on cases raising environmental issues. Then in the Court of Appeal, again, that was that sort of work, although we did get some sort of discrete issues. I think someone reminded me, and Liz reminded me when our notes on this, of a case which I did in the Court of Appeal about the definition of waste for the purposes of the European directives, which was fascinating in a way, because in the context of European law, one was trying to work out how waste was defined in a number of different languages, all of which were meant to say the same thing but didn't. So that was quite interesting. But I think, again, my main contact with environmental law was through the judicial review. Then I was senior president of tribunals, as has been mentioned. I was quite keen to sort of see if we couldn't develop an environmental tribunal jurisdiction. And I had, some of you will know, Professor Richard McCrory, who was hoping to be here tonight. But we planned a lot to see if we couldn't sort of persuade someone that we should develop an environmental jurisdiction rather like your jurisdiction. Indeed, we were wondering whether we could bring the inspectorate into that, because but there wasn't the political will to do that, so it didn't happen. But there is a sort of residual jurisdiction in the tribunal system, which is a sort of I can't. It's sort of certain things about certain types of regulatory jurisdiction have an appeal to what's called the General Regulatory Tribunal, and there's a branch of that which calls itself the Environmental Tribunal, but is a fairly minor part of the work. Then in the Supreme Court, one just does anything that comes, and if anything environmental came along, I was usually asked to write the lead judgment. There was a very significant case called Client Earth about air pollution levels in London and failures to comply with European legislation, which I think was quite important, because it was the first time we'd actually sort of told the government, you've got to improve your plan, and they were told to go away and produce a better plan. And I think it was the first time we had actually said, in making an order, the Client Earth, you can go back, you don't need to start new proceedings, you can go back to the administrative court. And that happened, I think, twice. That was quite significant. There were, again, a number of planning cases in which one was trying to sort of try and sort of sort out the complications of judgments below and try and produce a coherent system for the planning regime. There was one or two cases, I think, about environmental impact assessments. One of my favourite cases actually was not in the Supreme Court, it was in the Privy Council, because you probably know we hear appeals from various Commonwealth countries which still have a right of appeal to the Privy Council, and some of those are environmental. And there was a body from Trinidad called the Fishermen and Friends of the Sea, which is a lovely title, and that was a case about polluter pays principle, actually, and the extent to which that was applied in Trinidad and whether they had correctly transposed it into the legal system there, and we said they hadn't. It actually, I was looking at my judgment again, actually, and it was quite interesting. I start by saying this is the first case we've actually heard digitally online from the in the Privy Council, and that was a novelty then, but of course that was the first of many. I mean, since then, of course, most of the Privy Council cases are heard online, not just because of COVID, but actually it's rather more convenient. So it's a miscellany, so I can't offer you any very coherent system, but we've done a bit of environmental work in my time.
That reminds me, and I think Jane might be in the audience tonight, that you came up a number of years ago to give a talk in Oxford where you reflected on the range of the different cases that you decided on the Supreme Court. And I remember, I think Jane walked out and said, I've just had my revision tutorial with Lord Carnwath. But I'm going to move the questions round a bit, because I think what both of you have described is this diversity of the work you do in the environmental space. And I can even think of more examples. I can think of the Indigenous heritage work that the Land and Environment Court does, the cases on village greens that the Supreme Court has had to decide. And I guess the question is, do environmental problems throw up anything unique for adjudication? Or are they, in a sense, given all the diversity of the other things that you're thinking about, land valuation, etc., is there anything unique about the environmental problems? So we might start with Robert and then go to Nicola.
I don't. It's difficult because there are such different cases. I mean, what I think is typical of environmental cases, may not be unique, is you're dealing with a variety of different interlocking things of law, policy, and fact. And the policy element is always generally a very significant part of it, and the extent to which one's prepared to sort of interfere with policy matters is quite a significant element, and something which actually does cause problems. But I think that's a feature of them, which is not necessarily unique, but it certainly is quite a strong feature.
Yes, look, I probably wouldn't use the word unique either, but I would agree with what Robert said. But I suppose the thing I'd mention that is one of the there's quite a lot of discussion about whether specialised courts are a good idea, and there are arguments for and against. The United Nations Environment Programme's just done a substantial report, I think it was published this year, that's identified over 2,000 things that could be described as an environment court or tribunal. So there certainly are lots of attempts around the world to do it, and they're not all successful. But I suppose one of the things that I think is a challenge is dealing with the expert evidence as a trial court. So, but a lot of disciplines a lot of litigation requires expert evidence. So that of itself isn't unique about environmental matters, but they are pretty expert heavy, I can say. And I think for judges that's quite a change, and certainly over the time I've been on the bench, the way expert evidence is dealt with as a process has really changed a lot, and as it has in other areas, to try and get the best out of those experts in terms of them assisting the court. So,
you say a little bit more about that, because it is what the Land and Environment Court does is unique in this space, and having sort of I know people in the Land and Environment Court don't think it's unique.
No, we don't.
but it's called hot tubbing, which only the Australians would call it hot tubbing.
we actually prefer to say concurrent evidence, actually, but known colloquially as hot tubbing, which, yes, well, I'm certainly happy to talk about that. And we are a small court by court standards. That's a small number. I don't know if I said the number of judges. There's 6 judges. I think I told you how many commissioners there are. So that means that we can try things, and one of the ideas, we have tried over time various things with experts. We used to have, at one stage, we tried to have single experts, not dual experts in particular kinds of disciplines. Now we often will have 2 or more experts, but the aim is that experts are there to assist the court, not to advocate for the parties. That's the theory. So what processes do you need to make sure you're getting assistance out of those experts? And a lot of effort does go into that. We have extensive practice directions, as do many other courts increasingly now in Australia anyway, to case manage expert evidence. We make the experts meet. They have to identify the issues. Often that leads to settlement of a large number of issues on the way through. We exclude the lawyers from those discussions. We just want the experts to meet and apply their expertise as between them. So if a matter doesn't settle, and we do put a lot of emphasis on mediation and conciliation in the court, pretty much everything but criminal will probably have somebody suggesting along the way that this should be done. There is some classes of cases where it's compulsory. But anyway, if you get to adjudication, and don't worry, I'm very busy as a judge, so lots doesn't settle. But then in court, we have this process of concurrent evidence where all the relevant experts in a discipline are sworn in. So probably the maximum I've had is 4, but some of my colleagues have had more than that at one time. You swear all those experts in, and each judge would probably run it slightly differently, but the aim is, from my point of view, is to go through issue by issue and hear from all those experts. There is cross-examination by barristers, that's certainly not precluded by this process, but compared to when I first was sitting as a judge, where you would hear one expert essentially serially, and you'd be waiting for that key question to come finally, this is much faster, and I suppose I find it more efficient and also better for my understanding of the expert evidence to hear it this way. So you can ask an expert, what do you think about that? And you can ask experts to comment on each other. I think it does require more upfront work from the judge in terms of reading reports, but I would think all my colleagues would say they have a better grasp of the expert evidence as a result of that, and it certainly is more time efficient in doing it that way. So, but we're not the only court to be doing this, but we were an early adopter, I can say, of that process.
I don't know.
Well, I'm fortunately, I'm slightly out of touch with what goes on in the High Court nowadays, but I'm sure they do that. I mean, certainly when I was there, one was always trying to get the experts to agree and try and narrow the issues. And to some extent, some judges are more proactive than others, but I'm sure there may be people here who have more direct familiarity, but I'm quite sure we do, whether we call it, I think we call it hot tubbing as well.
So in the Richards case, so the Richards case from September last year, he has a little subheading, hot tubbing.
Yes.
Which was one of the first, I think, judicial review cases
Right.
it was operating in. I wanted to just come back before I move on to the next question about policy. because I think, and a conversation I was having on the train coming down is, it is something that I think students learning environmental law and planning law are very shocked by. You know, suddenly you've got law, and then you've got policy, which is soft law. Is it internal law? Is it guide? You know, what is its legal status? It's kind of law that's not law. And I think Brian Preston's got a piece coming out in the Australian Journal of Administrative Law on policy, where as a lawyer, you know, this is what he's used to dealing with, but other lawyers find it very strange to be dealing with this. But we'll move on to my next question, which
Are we going back to policy?
No, do you want to explain?
Well, I'm just I'm very interested to know how, in your court, you deal with policy, in the sense that you're a merits review. You're not policy makers, so you're presumably taking on board the policies of whoever the planning authority or the planning authorities are.
Yeah, I mean, I can comment. I was going to say, it is pretty structured.
Yes.
Because the legislation, for example, we're administering may well refer to policies, for example. So that will be able to be identified through that. You can't just pick everything off the shelf. So within that, though, there will be potentially a broad range of policies that are applicable, but they've been made through a process by either local or state government. So they'll have a known status, and if they're a draft, they'll clearly say they're draft, and you know they will have less weight if they're a draft policy. But look, I did do a judicial review case on whether a planning commission had taken into account a very, very broad state policy on greenhouse gas emissions in assessing a coal mine proposal and saying no to it. And that was a policy that I thought fitted the statutory description, and so I said there was no illegality in the way they'd made that rule. So and made that decision based in part on applying this extremely broadly worded policy in the absence of anything else. So it is structured decision making. It's certainly not open slather.
No, but I mean, sorry if I can just. I'm more interested in how you exercise your merits review.
Oh, sorry. Right.
I mean, that's judicial review, which is saying we have the same sort of issues, but you have a merits review. So to what extent can you, when you're deciding whether to approve a planning permission for something, question the policy, the underlying policy that the authorities produced?
Well, that'll be part of the exercise of discretion, but we'll have the same policies as the original decision maker made, although in fact if the law had changed or there was a new policy, we'd have the new policy before us. Merits review means the court, whether it be commissioner or judge, is making the decision as if the original decision maker, but we don't rely on what was before the original decision maker. The parties essentially get another go. It's a hearing de novo, we say, and so we have to go on the evidence before us, which will include relevant policies. We would rely on the parties to tell us what they are, but that they may well be a discretionary judgment as to how that policy is applied. We're not bound by what the local council's always done with that policy.
But are you bound by the policy? I mean, can you say that's a silly policy?
That's a good question. I think if we thought it was inappropriate, we'd say that. I haven't faced that directly, Robert, so I'm sorry. We do have pretty broad discretion, so it's probably theoretically available. Hopefully we're not faced with that, I'll say in my... otherwise I really haven't faced that directly.
No.
It's a good question.
One of the things I find very interesting is that policy is very carefully drafted in the New South Wales compared to some of the policies that we're using within the kind of English setting. You know, and that does make the quality of policy really matters. I'm going to move the questions around again because merits review and judicial review. So in the UK, we think of merits review in the kind of planning inspector. Of course, the feature of the Land and Environment Court is you're doing both merits review and judicial review. But Robert, you must have had experience of kind of sort of tribunals and thinking about kind of merits review. I mean, what do you think are the advantages and the disadvantages of each in the kind of environmental space, broadly defined?
I mean, I probably wouldn't use the words advantages and disadvantages. I guess from a judicial perspective, they just do extremely different work. So the frustration may be more with the parties in terms of what they're trying to achieve than from the judge's perspective. But they are what they are. If you have an appeal right in the New South Wales as an applicant for development, you can exercise that. There are limited objector provisions so that members of the community who have objected to particularly large developments, they're called designated developments, they have an automatic right to be joined as a party. So you may have the local planning authority, the applicant for development and possibly another party in the mix. And the court actually does have power, if somebody applies to join them if it's in the interest of justice. So it does mean that for larger developments, certainly where there are contentions and the court thinks an objector or a person applying to join as a party can add to the issues in a useful way, they can be joined. So we will often have, on larger matters, major issues raised before us by not the local council authority, the approving it, or the state government, or the developer. And one example of that is there was a coal mine that was refused by the court, and that certainly got a lot of media comment at the time, and I think that partly was based on greenhouse gas emissions that would be caused by the burning of the coal, the Scope 3 emissions. The objector who would join, so it wasn't an objector, it was a community group, was allowed to join as a party, and they raised those issues and brought forward expert evidence in that space. So that does mean the court, in merits review, can get a very thorough look at the issues, and that's sort of the job of the court then, that they're doing what the decision maker should have done at first instance anyway. So that's one function. Judicial review, applying administrative law principles that are well known, albeit in an environmental context, a statutory context, is determining whether or not the decision maker made the decision legally or not. And usually the remedy is making a declaration of invalidity if the decision was invalid. So it does just have a very different function.
I don't know.
Yes, I mean, I agree. I don't think there's a question of one being a disadvantage as the other. I mean, they both have different functions. And obviously, if you're thinking from the position of an appellate court, even when you're reviewing, when you have an appeal on fact as well as law, one normally exercises a degree of restraint because one works on the principle that certainly if there's been oral evidence, the trial judge has the advantage of seeing the witnesses and forming the view. So on the whole, you don't interfere unless he's obviously gone wrong. It's different to some extent when you have where the evidence is all in writing and you can see the same things. But on the whole, there's a sort of degree of respect, even when it's pure on fact, a respect for the trial judge's judgment, particularly on issues of discretion. So, I mean, there's a sort of continuum. There's no sort of sharp division, but I think as we were used to doing both and when they're needed.
I mean, it's interesting, Nicola, you highlight that, and I don't know if you meant to suggest this, but the people arguing the cases before you might not think carefully about the differences, but it is really important in cases being argued.
Oh, well, I suppose I'm just saying that because at various times I see articles expressing frustration with judicial review, but that's just what it is. I think I've seen articles from environmental lawyers in Australia sort of acting for environment groups saying, you know, are we getting what we need out of judicial review or should we be looking at other strategies? But that's what I mean. As a judge, it's just you're doing the job, as I think Robert would say. And we're bound by those. And there's very strict, even from the High Court, which is Australia's highest court, very strict guidance about you must not get into the merits of the decision. That's on a merits review case. On a judicial review case. And that is often the arguments raised are probably really trying to argue the merits, and that's not something a judge is supposed to be looking at in judicial review proceedings.
I mean, it is an interesting, you know, there are strands of environmental law scholarship which are in a sense expecting something of judges in particular legal roles which is just actually impossible for them to deliver. But we should move on, and where I want to come next is to think about judgments and the process of judgments. And to do that, I want to quote from a speech you made in 2015, Justice Pain, and you said, "As a judge, clarity of reasoning and legal analysis is key. Intellectual leadership is involved in the sense that I am often deciding matters which have not been decided before. Leadership goes with the job." Now, I think that's a fantastic statement. And I think what really struck me was this mixture of both clarity of reasoning and intellectual leadership mixed together. So I don't know if you want to expand on that. Now I've embarrassed you. And it would be interesting to get Robert's thoughts on this as well.
Look, I think I was being asked to reflect on my role in leadership terms, which is probably why I use that word, and I suppose you don't often see it in relation to judges when I think about it, but I would like to emphasise that it is certainly in no way a mechanical role. So, and even though I'm in a statutory court and you think, well, you know, it's all in the statute, what could be hard about that? But we are constantly dealing with new issues, and yes, it is certainly the job of the parties to present their arguments before me, and I've got to deal with them. But it isn't just, that is, and I'm sure Rob will agree, that's not a mechanical thing. You really, as a judge, often have to really think through the issues. So I think it is valid to describe that as intellectual leadership, which is what I did in that quote. And I can tell you, it is so exacting having to give reasons for your decision. Just imagine if you had to give reasons for your decision in your daily job. But that's the life of a judge, and it means that you are always very focused on your legal analysis. So it is part of the territory that goes with it.
Well, I never thought of it in those terms, but it's interesting to think of. I mean, obviously in the Supreme Court, you are very much trying to lead the way the jurisdiction is going and the way the case law is going, and you have to make a decision as to how proactive you're going to be, because it's. I mean, take the Client Earth case. The Court of Appeal had there said that it was really a matter for the European Commission to enforce the European laws on pollution, and it wasn't really something which the courts should be getting involved in because it was very technical and very political. Now we're rather weak, to be honest with you, because we thought we'd better refer that to the European Court. We didn't sort of immediately take a strong lead, but I think there's sort of partly because within the, when you're dealing with 5 people in the Supreme Court, you may get different views, and some are more cautious than others. So we did refer it to the European Court. And I was very pleased that the European Court came back and said, you get on with it, that's what you're there to do, is to enforce. So we then, in the judgment, we were very conscious on was trying to sort of give a very strong signal as to what the government should be doing, and a very strong lead to the courts as to how that, and to the parties as to how to take that forward. So I think one's always thinking in those sort of, at least I hope one's always thinking in those sort of terms of where is this actually going and how is it going to help the parties.
And of course it's interesting that adjudication is about a decision for the parties in front of you. That intellectual leadership is to the legal community. It's also to students and reading the text and learning about what is the law, particularly as you, again coming back to this quote, in issues which haven't necessarily been decided before.
I think actually the Fishermen and Friends of the Sea was a very interesting one, because there, the issue was the charges that the government was making to water polluters, people who were sending water, discharging water from industrial plants and things, and they had to pay charges for licenses. And under the legislation, which was meant to interpret the polluter pays principle, that was meant to reflect the cost to the authorities of administering the thing, but it didn't properly reflect it, and we said it didn't really comply with the polluter pays principle. But there was a problem then what to do about it, because if you said that the charges were all invalid, that would upset everything, and you would find that people were claiming all their charges back because they had been invalidly levied. And so what we said, well, actually, we'll direct the government should prepare a new scheme of charges, and we gave them a sort of time limit to do that, but that in the meantime it shouldn't affect the validity of the charges levied hitherto. And we said that, and it went into the order, and everyone seems to have accepted, and I assume it worked. But funnily enough, that was here there was certainly under the authorities some doubt about whether that would work. And it was quite interesting that in the most recent Judicial Review Act, the government accepted the recommendation that they should give the court the power to suspend in those sort of circumstances and have much more flexible remedies. But I mean, we basically did that because otherwise it would just produce a chaotic situation.
Well, that sounds like leadership to me, Robert.
I don't think so.
Leadership in a separation of powers setting. Do a seminar on that.
Yes, that's a good title.
But I want to bring in another dimension to all of this, and that's international law. Because many people, when we think about environmental problems, they think globally. The picture of planet Earth, and so there's often an assumption that the answer lies at that global level. Now, of course, both Australia and the UK are dualist legal systems. International law doesn't have any kind of obvious direct legal effect within a jurisdiction. And that raises a question, what is the promises, what are the pitfalls of international law? What is the role of international law in judging in the environmental space?
Well, I'll speak first as a domestic judge. So most of the time, or pretty much all the time, I'm applying domestic law. As Liz has said, international law doesn't apply in Australia until the Australian government chooses to apply it. So I think there certainly have been judgments where international law might provide a context. It's not that you would necessarily be applying it directly. And I guess climate change, for me, is one of those interesting contexts where domestic courts are being asked to deal regularly with what is a global problem, the ultimate cumulative impact problem. So in that context, it's very hard to only look within, my jurisdiction's within New South Wales, but of course greenhouse gases apply and are fungible across the globe. So certainly there's judgments of the court which have looked at that international context, I suppose more in a soft law way. It can't be applied directly, but you can't say it's irrelevant to understand, for example, the evidence you're receiving from climate scientists. They'll be referring to the international framework because that's an important part of how climate science is being developed. So certainly the framework would influence the evidence the court's hearing, and it may assist the court's reasoning to be aware of that context.
Yes. Well, we're in the same position. We don't, international law as such doesn't apply. Of course, we have had the particular issue of Europe, where we've been applying European law, and we'll go on doing so for a certain amount of time, depending on what the government does with us. But that's a special issue. And of course, human rights, the European Convention and international law, which we were required to take account of. I think the climate change is an interesting one because the extent to which the international convention can be a relevant, to create a legitimate expectation, I think.
Yes, although it hasn't.
It hasn't lasted very well.
Not very well.
No, I don't think. So So I think the answer is it's there in the background, but it doesn't actually impinge very much on one's day-to-day work.
And so I should put a bit more of a detail in there. I'm from a federal system, so most environmental law and decision making does happen at the state level, but we have a national government and they do have some environmental legislation and they do have a limited role. So in fact, the federal court, which applies the national legislation, has had to look at things like the World Heritage Convention because under the Australian Constitution, if the Australian government enters into an international agreement and implements that in Australia as Australian law, then it has done that, say, with the World Heritage Convention, we have national legislation that has to be applied and that's been enforced in the court. So in that case, there would be a direct correlation in an environmental context, but at the state level, much less clear connection, if any.
And that's an excellent example of how much in this space you're often starting with legislation. So if we think about the Paris Agreement in the UK and the Heathrow case, you know, the issue there is Section 5.8 of the Planning Act, which says, you know, they have to take, you know, the reasons have to take into account, you know, government capital G policy on mitigating and adapting to climate change. But I mean, international law, I guess, has had an important role in my view, in kind of framing climate change as a problem. As George Marshall has said, you know, it's multivalent. It could be anything and everything. And actually giving it sort of boundaries of saying, this is what climate change is as a problem, and here is a target. And I think the Paris Agreement has been very significant in that regard.
Yeah, I'm thinking more about this. I think it's in evidence that's particularly important. So, for example, I've had to deal with a coastal property being inundated, potentially, because of sea level rise increasing that. And so the coastal engineers in that matter, they had to use IPCC modelling and apply it locally because there just isn't anything in between. So they were able to do that, but that was a direct, I mean, that's not necessarily law, that's just the methodology of how do you work out what's going to happen with sea level rise. But in the absence of anything in between the IPCC and what you've got to work out locally, that's what the evidence requires, for example.
Yeah, and the kind of institutional needs to make sense of climate change. We've got about 5 minutes left, and I'm looking at our very strict chair, is that correct?
5 to 8.
Okay, thank you. As I said,
It's
very...
big questions you all have.
Yeah. But I want to move on to a speech that you gave in 2019, Lord Carnwath, where you imagined, it's a wonderful speech, you can find it on the Supreme Court website, you imagined having a conversation outside the Supreme Court with one of the environmental kind of protesters who were protesting in Parliament Square at the time. And in that hypothetical conversation, you said you would sort of say the following: to me as an environmental lawyer and judge, the crucial point is that we have more than political commitments or even general human rights protections. We have a strong legal framework with clear and enforceable precise targets based on independent expert advice. We need to direct all our efforts to achieving comparable legal regimes across the globe. And I was just wondering if you could expand on your thinking about that statement. I think it's a really significant statement in 2 different ways. But before I explain what I think is significant,
I remember distinctly sitting. I mean, I had a very nice room looking over, when I was in the Supreme Court, looking over Parliament Square. And I remember looking at it, and I came in one day, they decided to sort of set up the Extinction Rebellion protesters were outside, and they'd actually been allowed to put a little tent just outside our door, and you know, I came in, I don't think they knew who I was when I came past, and went in, and I was watching down from upstairs, and just thinking, well, what do they actually think the Supreme Court is doing? You know, do they realise that this is actually quite a significant place? And I said, you know, I was thought what I'd asked is what actually do they think should happen? Because in this country we do have we were very lucky. We had a Climate Change Act 2008, which is very advanced, and it is a strong act. I mean, it's got a very clear framework. It's got sets clear targets, clear machinery requiring 6-year budgets to be reviewed and so on. And it has the Climate Change Committee, which has proved itself already quite a strong independent force. And I was ready to think, well, what more can the law do? I mean, you know, you can stick your face to the M25 and say it's not good enough. But actually, I'm not sure there is much more that the government can do than have an act, but then comply with it, of course. And I think what's very interesting about the recent case, the Carnwath case, which was about actually making sure that the targets mean something. You know, they've got these plans, the budget, but do they actually say how they're going to achieve them? And hitherto, the government on the whole can say, well, we have actually kept up with the actual requirements in our budgets. But now the court is saying, well, you know, there's no use having a sort of plan up to 2036 or whatever it is, unless you actually show what is going to happen in different sectors. And I think it's going to be, and the court has told the government to come back with a plan by, I can't remember, next April, is it? And I think it's actually quite strong, that. I mean, you know, so I was just thinking, if one was having a discussion with the Extinction Rebellion or any of these people, trying to work out what it is they want, which is different to what we've got. But certainly they can look to Australia and a lot of other countries and say, well, you haven't got anything like that. It's about time you did. So that was my sort of perception. And in fact, was a talk I gave. I mean, I think I was at an international conference. I was making that point. We illustrated with picture films of them. You know, I had a sort of PowerPoint with illustrations of the films of people with their banners down below the Supreme Court.
Well, when I read this quote, I wasn't thinking so much in the climate change space as one of the challenges, one of the points made in that quote is the need for sort of a common approach. And certainly, well, we don't, in the climate change space, Australia doesn't have things like the UK's legislation, and with a new national government that's changing as we speak. But yeah, there's certainly not unanimity about whether they're going far enough. But one of Australia's challenges is, and that's the thing I've just referred to, because we're a federal system, each state does do its own thing, and certainly on a national problem that can lead to 6 different approaches. So in some cases the Commonwealth tries to act as leader, and so in water management it's tried to do that with the Murray-Darling Basin, where the states agree to give power to the Commonwealth and they act cooperatively, but still the administration of that happens at the state level. So I think for Australia, sort of outside the climate change context, which has big challenges in terms of law for Australia, one of those issues is how do you deal with cross-boundary issues in a system which doesn't recognise that explicitly.
Should we maybe take some questions?
So yeah, shall we? I've got a few quick kind of comments.
Exactly. What are your comments?
But I think my last question we've kind of followed, but I just wanted to follow up on that. So your example of the recent Climate Change Act case, Robert, is there was a statement you made in an article, I think in 2014, where you said, as a judge, the role is not to follow through on the courage of my convictions, but to follow through on the courage of the government's convictions. You know, if they put this in legislation, the role of the judge is to say, well, okay, you know, you then need to follow through on it. It also struck me, I mean, this statement is a statement about the importance of the environmental rule of law and the benefits. And if we take Australia as an example, which doesn't have comprehensive climate change legislation, and one of the, not all aspects of the industry, but part of the energy industry is like, this is a nightmare for us as well, because we kind of know what the direction of travel is. But it's very unclear, you know, how do we make wise investment decisions when we don't have that clear legal framework? You know, so the importance of kind of the environmental rule of law, which I know you've done a lot of work on with UNEP, Robert, and I thought this was a lovely statement of that. So shall I move on to my general... Okay, so anyone who's heard me talk, you will always know about how I get very cross with talking about climate change or environmental litigation. And I get very cross with it because it overlooks the importance of adjudication. The role of a judge is about adjudicating on the case before them within a common law system on the basis of the legal arguments put before them. and the quality of those legal arguments really matter. And what I think is distinct, and I think you're right, environmental law is not unique, but it has distinctive. And part of its distinctiveness is the point from the quote that I read from you, Justice Pain, which is that you're often deciding questions which haven't been decided before. I spent a year when I was finished law school working in the Chancery Division and the Equity Division of New South Wales Supreme Court, and there were really hard issues there, but actually they were the same issues again. They were just, there were grooves of centuries of legal reasoning for you to work with, and that's not to say they weren't difficult, but there were those grooves. Get into the environmental law space, and often you're deciding questions that haven't been decided before, often because the legislation is constantly changing. And that does make it a very different type of both adjudication, but also a very different role for the lawyers who are appearing in that space. And then I have two further points before we open up for discussion. One is about this idea of distinctiveness has two different aspects to it. One is about the types of law that are being dealt with. Brian in the book describes this as kind of contributory expertise. That as in the environmental law space, there are particular types of law that you need expertise in. If you don't like administrative law, don't become an environmental, don't become an environmental law barrister, because there's a lot of administrative law. There is a lot of policy work in this space. And so part of the expertise in this space is that expertise with contributing to this area of law. But as particularly Justice Pain highlighted, there is also this need for interactional expertise, dealing with information about environmental problems. And that can come in many different forms. I think we often think of a kind of expert as if they're sort of, they've got glasses and they've got a clipboard. But in these cases, and again, if I think about the Land and Environment Court, the type of experts coming in are very, very diverse. And the type of information coming into the court is very diverse. So a case like Bulga in 2014, there were experts talking about loss of place if you take away a mountain ridge. That's a sociological kind of phenomenon. And then my final point, and this is the one I wanted to end up on, is this importance about transparency. So one of the really striking differences, besides all the organisational differences between something like the Land and Environment Court and the Planning Inspectorate in this country, is that everything the Land and Environment Court does, including all the kind of interlocutory stuff, you can read on their not their website, but the Case Law, New South Wales sort of case law website. Everything is available. In this country, getting any decision from the Planning Inspectorate, unless you know the planning number, is very difficult. And even our High Court, a project that I did a couple of years ago with one of my colleagues in Oxford, we wanted to read a year's worth of administrative court decisions, and we got 802, and that was pretty good, and that was really interesting. But we couldn't get all the decisions. And we didn't know how many decisions we were missing. So that transparency, coming back to that idea about intellectual leadership, is showing your reasoning. If you can't actually see it, that makes it very difficult. And where I'll end is, I don't know if any of you know, but last Friday, the Lands Tribunal, which is a very different institutional sort of beast from the Land and Environment Court, the Lands Tribunal of Queensland handed down a 352-page decision in Waratah Coal, which is another merits, well, it's not a merits review. The Lands Tribunal is a bit like the Planning Inspectorate here. And it's an extraordinary decision. I'm only up to paragraph 709 at the moment, which is going through all the arguments for giving consent to this coal mine. And it is that transparency. It is the kind of showing the reasoning, which is so important, and to me is really at the heart of environmental judging. So I'm going to end it there. Can I thank you so much for putting up with my pesky, nerdy questions?
Not at all.
We might have time for your last question there, but let's see. Let's hand over to the audience. I've got 2 questions online so far, and I might start with one of them. So after that question, I will come to the audience. And this is for you, Robert. It picks up a point you made in your answer to your first question about the role of the first-tier tribunal. And I think it relates to the project that you were talking about, of thinking about its potential jurisdiction. So appeals against environmental regulator permitting decisions are mainly decided by the first-tier tribunal. Should the first-tier tribunal have a greater role, for example, in deciding cases about environmental pollution?
Well, I would have liked to do. I mean, I would like to develop that jurisdiction to extend, well, things like the statutory nuisance, which I mentioned, where I think some of those cases were much better decided by a specialist tribunal. And I'm sure there are lots of others which would be suitable for that. It didn't happen because the politics weren't there. I mean, it was quite, I mean, people may not know this, but I was involved, the tribunals, we used to have lots and lots of different tribunals covering different things, subjects, mental health, tax, social security, all sorts of things. And it was decided, following a report by Sir Andrew Leggett, former Court of Appeal judge, that these should be brought together into a sort of more coherent structure. And that's what was done under the Tribunal Courts and Enforcement Act of 2007. And I was sort of overseeing that from a judicial point of view. And on the whole, we achieved quite a degree of coherence, of getting a sort of structure of an upper tribunal and a first-tier tribunal with different chambers. But, and there was a sort of political impetus about getting it going along the basis suggested by Andrew Leggett. But after a bit, the political impetus ran out and the politics moved on to other things. So various things which I'd have liked to have done, like developing an proper environmental jurisdiction, there was no will to do that, and so it didn't happen. But the answer, I mean, I would have liked to have taken it further. But
it's interesting you speak about this as history that's done and dusted, and I guess the question is kind of anticipating that maybe that story is not yet finished, and that, I mean, the history of the London Environment Court is of politics meeting in a moment that led to the birth of that court, and who knows where we'll be.
Well,
yes.
At the moment, the sort of political scene is such a muddle.
We're dealing with other issues.
And well, we were trying, where the environment law is going with the sort of Europe. It's a chaotic situation at the moment, and I'm glad we've got the Office of Environmental Protection, which hopefully is going to be pushing the government to produce some sort of coherent policy. But it is an awful mess. So I don't think anyone's going to be worrying too much about the adjudication for the next 5 years or so.
No, yes, exactly, short term. Questions from the audience? And do you mind, maybe just speak up. I will repeat your question so the people online can hear.
Okay, thank you, Professor. I just have a question about, because sometimes environmental judging involves a balance between public interest and the private interest. I'm wondering, in practice, how judges balance these two, and are there some principles guiding you to make this balance?
So the question is about often environmental cases involve some form of, or involve both public interest and private interests. How do judges deal with balancing those considerations? It's a broad question, and I wonder if bringing it into a specific context might help answer the question, but
Well, have a go. But certainly in merits review, that is a circumstance that often a commissioner and or a judge will be facing, so they will have a raft of policies potentially that they have to consider. They'll have evidence they have to consider about whether this particular development should happen and whether the environmental harm from that development is too great. Frankly, it's balancing up. It's hard to give you a general guide because it really, each case does depend on its own circumstance. But I mean, if the environmental harm is too great, potentially, then that would outweigh the need for the development. But that is very much something that's within the discretion of the court to decide, as for the original decision maker, as to whether it's ultimately in the community interest for a particular development to happen. But it's certainly a common issue that the court's got to look at. And I suppose that's one of the hallmarks of, in terms of environmental adjudication, that is worth mentioning, that there is this public aspect of it. I mean, you know, environment belongs to everybody, so how do you balance that out?
And just before I come to you, Robert, I think your answer is prompting me to think that I guess there's two ways in which the public interest can be brought into a lot of cases. One is that it's kind of there indirectly because there is a public interest in environmental issues, whether it be evolution or climate change or nature conservation. But in your court, Justice Pain, actually in the statute, there is such a thing as the public interest that you need to take into account as a statutory consideration, which doctrinally has led to the breeding of all sorts of interesting arguments about what can be taken into account.
I think you should answer this question, Eloise.
No, but there's two kinds of public interest.
She's right. Under the main planning legislation, there are a whole lot of things the court must consider, including policies. But my answer, Robert, is we wouldn't have to apply the policy now that I've thought about that more, as long as we consider it. But yeah, one of the things we have to consider is public interest, but there's no hierarchy, there's just a list. So ultimately the court's got to decide, based on the evidence, based on the arguments, what's the appropriate response. But yes, it is very explicit, and that has certainly been very broadly interpreted in many judgments over many years now, as Eloise so cleverly pointed out.
But that's in the planning context.
Yes, that's in the planning context.
Yeah. Lord Carnwath?
Well, I'm not sure I can add anything. I think one hopes that the law or the policies are clear enough to give a pretty good sense of how you balance public and private interests. But there certainly are statutory contexts, as you mentioned, where you get a list of things you've got to take into account, which include the public interest and private interests, but doesn't tell you how you weight them and what you do. And I mean, I've no easy answer to that, frankly, because you look for guidance where you can find it, but I think it's very unsatisfactory as a judge to be put in the position of actually balancing these intangible things. So it's not easy.
But in merits review, that's the function. The original decision maker had to hopefully weigh up all those things, and on appeal, the court, whether it's a commissioner or judge, is doing that same function. So somebody has to often, that's part and parcel of society, somebody's got to make those judgment calls. And in some contexts, in development contexts, there are appeal provisions, and the court or tribunal has to make those decisions as well. That's what society requires.
So just a different dimension on this, and I guess I'd say, you know, legislation plays a powerful role, but so does the parties. And this is where we kind of, you know, so in a sense, within an adversarial system traditionally focused on parties protecting their private rights, there is a richer set of legal sort of resources and thinking there. You know, one of the challenges is making arguments about making good legal arguments about the public interest. And if we take the example that you cited of Gloucester Resources, where the community group was joined and then they could make the argument about climate change. But if they hadn't been joined, those legal arguments wouldn't be put. And of course, just because a party is in the mix doesn't mean that the legal arguments are going to be necessarily quality. And in that, I just come back to the Environmental Defender's Office, which, you know, it's such a significant role. And one of the chapters in this book highlights it. You know, the court couldn't be the success that it is, the New South Wales Land and Environment Court, without a legal community around it of barristers putting arguments.
True.
I'll come for more questions, and I think, but something that on this is such a good question is that all of the discussion about your practice in your courts has not drawn a distinction between public interest litigation and other kinds of cases that come before your court, because they're just things that come before you. But I think in the, you know, behind that question maybe, but in the public's imagination, there is a lot of attention about the public interest that drives litigation. That is not something that is kind of, you know, from your perspective, but I imagine that's where a lot of the interest, potentially from our audience this evening, is kind of coming from as well. Any more questions? I'll come to you next. Is there a lady at the back? And I'll repeat your question.
Do you think that legislators are being reactive enough when it comes to legislating against certain like environmental and climate change issues? Because I know that in certain circumstances, by the time something becomes law, the reality has moved on. So do you think that the legislation is moving quickly enough? And if not, I'd be curious to know why not.
Okay, great question. The question is, are legislators being reactive enough or potentially proactive enough in dealing with environmental issues? The suggestion being that by the time law appears, maybe it's behind the scale or challenge of the problem, the environmental problem it needs to be dealing with. And do you have thoughts on this question as judicial officers?
Well, I'm not sure if we should have thoughts as judicial officers on this topic. Certainly in New South Wales we have some very good comprehensive legislation dealing with the criminal side of things and the civil side, and I suppose I'm thinking the framework is broad, so new issues could arise in that. Certainly in climate change, Australia has lacked legislation, full stop, compared to the UK. Now there's a very interesting decision actually by the Chief Judge of the Court in last year perhaps, bushfires. And so a public interest group brought an action. They were called bushfire survivors because they were a group that formed after the terrible 2019-2020 bushfires in Australia that were devastating and very expansive. And they were arguing that the Environment Protection Authority should have a policy and was required by its legislation that does regulate it to have a policy about climate change, and the court held that they did have to have a policy. And I think they've just released a draft in September in response to that decision last year. And I haven't actually had the time to read it, but I'm told it does now look at whether or not they may look at regulating, for example, greenhouse gas emissions. So that's quite a major development, and that arose from that court case. So and there's clearly a need for legislation in that area. Without specific examples, it's hard to give you more precise argument because there are so many discrete environmental issues that need different legal response.
Now, Robert, Lord Carnwath, you're freer to speak on this, perhaps. And we're in a context in the UK where all of our legislation might be disappearing. So I wonder...
Well, I mean, that's the trouble. I mean, you can contrast the climate change, where we've got a good act, which has actually been updated to produce net zero. It's got, and it has built into it a process of updating it for each sort of 6-year period, and it seems to be a model of something which is actually looking forward and doing it in a legally clear way. Again, and we have the Environment Act of the last year or the year before, but
2021,
which requires the government to sort of produce a plan of where it's going in the environment. And then we have the mess of this sort of tearing up European Regulations Act, a bill. Where that's going, God alone knows. But I mean, at the moment, it's I don't know how anyone has a clue what the law is going to be in a year or two's time. But I just hope that things will settle down. So in that respect, the answer is no, they're not doing enough. But in the climate change context, yes.
I'm conscious of time, so was there 2 questions here? Yeah, if I take 2 of these, and I've got one more online. So Isra and Josh, do you want to both ask your questions, and then we'll come back?
Thanks. So this is a question for Justice Pain. So how much, so you said that kind of a lot of your work is kind of driven, well, the space is kind of quite policy driven. So I wanted to ask how much interpretive latitude on the meaning of the policy is afforded to judges in your jurisdiction. Say, for example, if you've got a dispute between a private party and a local authority or a state authority, is there any kind of presumption that what the authority says the policy means is going to kind of be determinative, or is there much more discretion for you as a judge?
I'm just going to take 2 and then I have to repeat them. So, yes.
My question, in brief, is how far do your personal experiences and values shape both what you decide and how you write it?
Okay.
And the reason I ask is in the case of Walton, Lord Hope gave a now famous metaphor involving kestrels flying around.
Ospreys.
Ospreys. Near his home, near some wind farms. which were threatened by the proposal. And it seems to me that nobody other than Lord Hope could have written it like that. So I'm curious to know how far personal experience shapes how you write.
And on the online question is on the very similar point. So I'm going to package these three questions and then come to both of you. So the first question is one specifically for Justice Pain about the New South Wales kind of environmental law and planning context, which was you described earlier as very kind of policy driven in a structured way. And the question is how much interpretive latitude is afforded to judges in that legislative context to interpret the meaning of policies. And the second question, which is, I'm going to kind of, there's two questions asking similar things. And the question from the floor was how far do personal experiences or values shape adjudication and shape judging? And the question online asks a similar kind of question in a different way. Does who the judge is matter in environmental judging? Lady Hale, for example, has regularly said that being a woman mattered to many of the cases she sat on. What would be the equivalent here? So, does who the judge is matter, and how far do personal experiences and values shape your judging? So, while you're thinking about that more challenging question, maybe the question about policy and how it's interpreted and how much latitude you have.
Yes, so in terms of policies, that's probably coming up in the merits review context most, but basically the commissioner or judge would hear arguments from either party. Nobody gets to be given greater weight, and ultimately it's a decision for the whoever's deciding it as to, if the policy is unclear, how it should be applied. There are statutory construction rules that might assist depending on the context, but there's no presumption the local authority is correct. Basically it hears from both parties and decides on that basis.
So, the personal question. How far do personal experiences or values shape your judging? Does who the judge is matter in environmental judging?
Good questions. I think for environmental, anybody could theoretically be an environmental judge, but I think the interest in the environment certainly is that you're a human being as well as being a judge. So certainly I would have come to the job. I had worked in government in environmental policy. I'd worked at the Environmental Defender's Office. I clearly had a strong interest, speaking personally, in matters environmental. So that's what I brought to the job. But if I displayed bias in my judgments, well, people can complain about my judgments if they think I'm too pro the environment. I can be appealed. None of that's happened. I swear an oath of judicial office, as you would be well aware, to decide things impartially and fairly. But I think judges do bring to bear their understanding of society broadly, and that's a good thing.
Lord Carnwath?
Yes, your example from Lord Hope was interesting because I was in that case, and I remember being slightly surprised when he came up with this sort of concurring judgment, but he was determined to get his Osprey in somewhere. And to be fair to him, he wasn't writing the lead judgment, but I think that the paragraph where he talks about the Osprey is very good, and I've quoted it quite often. But it could be in Kestrel, it could have been. I think, in my experience, it doesn't really affect I hope it doesn't affect the result, because one's sworn an oath to decide according to law and so on, but it certainly affects the way one presents a judgment sometimes. I mean, in the Friends of the Fishermen of the Sea that I mentioned, I was quite pleased to get the chance to write that lead judgment, because it enabled me to do a little introduction about the polluter pays principle, and I quote lots of various bits and pieces about that, which hadn't actually been cited with an argument, but I was quite keen to get them in. But when one got on to the actual meat of the case, I was deciding it according to the relevant law. And so certainly I think it does affect the way one may present the case, but I hope not the actual, the law and its application of the facts.
And the last one is for you. Yes.
Well, so just on that, I mean, I think it's a really good question. I think the danger is sometimes is that we end up with that kind of terrible sort of extreme form of legal realism where we say, oh, well, you know, whatever the decision is, it's what the judge had for breakfast or what they can see outside their kind of window. But it seems to me, and this is my kind of afterword in this book, is to think about what is it we think law is. And I think what's striking about this area is it's less about that and it's more about returning to Carl Llewellyn's ideas about traditional legal realism. How do we make legal propositions concrete? And that is in complex realities. And to me, one of the most striking features of the Land and Environment Court are site visits. And the fact that we don't do them in other cases, and the importance of a site visit, and the importance of actually going and seeing it. So the last question, and I'm going to be silent after this, is what do you think is the most underappreciated or overlooked aspect of the role of judges in environmental law? My answer is going to be site visits. But
Well, I have a go.
Yes.
I'm actually going to adopt something that Liz said to me because it actually was pause for thought, and that is some environmental cases are very controversial around the case, but no judge is caught in controversy. The judge is allocated literally the case. The judge has parties before them. The judge hopes they're going to put forward good evidence and good arguments, but they may or may not. And the judge has to decide the case based on that evidence and those arguments. So what the judge says very much reflects what's been put to them. And so if there happens to be controversy around that, that's not something the judge is seeking or probably has any view about. So I've been in the media quite a bit over the years for various things, and it's completely irrelevant to judges, I think, as to whether they're in the paper or not. But I think, the perception, particularly perhaps from non-lawyers, is that there is something the judge can influence or do about that. But we're really there to do a particular job, adjudication, based on what is presented. And so the ability for the community, for example, to put forward good arguments is really essential. And but that's not something the judge can control directly either. So I think the limits, it's an important job and obviously powerful in a way, but there are clear limits in what the judge is doing.
Robert?
Well, I agree. I think the fact that we are there to decide things independently on the basis of the material put in front of us. The classic example of that not being understood is not an environmental case, but the first Brexit case, where the divisional court decided the government against the government, and were castigated by the Daily Mail for being enemies of the people, a great headline, because they had decided in a way the Daily Mail didn't think was appropriate and was thought to be going too far, whereas in fact they were just deciding the case on the law as they saw it. And of course the other side of that was when I was in the Supreme Court, we by majority upheld the court below's decision, but I actually dissented in favour of the government, and I was then hailed by the Daily Mail as a champion of the people, which was a great, I'm not sure I was very keen on that, but my wife was very cross with her, but she's Italian, so. So I think, yes, I think it's terribly important for everyone to understand that what we're doing is to try and do our job of deciding things dispassionately, impartially, and on the basis of the law and the facts in front of us.
Thank you so much. Now, you may have more questions that you would like to ask, and there are drinks outside.
Oh,
so for those of you online, apologies, no drinks, but for those who are here, that's the reward for coming to Bentham House. But thank you very much to Lord Carnwath, to Justice Pain, to Professor Fisher for a really, really interesting discussion about environmental judging. Thank you so much.
Well done.